I think we're live. I do. I think, although my clock says 11:39, so I might have started it 1 minute early, which is really not fair of me. So I apologize. So I will vamp for until my clock says 11:40, even though, oh no, it says 11:39. So what can I do? So I'm early. I apologize to everybody for wasting your time, all 1 minute of it. Hope everybody is well. Who do I see out there? Again, I see, to the extent I could see this, Alan, Alen, which I like that name because my middle name is Alan, Alan. We see Mike, Joe, Stephen, Christopher, and we even see Mr. StreamYard. Hello, Mr. StreamYard. Nice to join us. And hi, Dustin, everybody out there. So it is now 11:40. So now we've reached the magical time. I probably should turn the mic towards me. It probably usually helps. We've reached the magical hour to start this wonderful thing. Thanks for joining me on a Saturday, wherever you are. Could be on a Sunday, could be next day, could be two. Yeah, it literally could be like 6 months from now. So if you're watching this 6 months from now, so first of all, you should have better things to do with your life. And beyond that, hello to you out there 6 months from now. So I'm in effect speaking to the future out there. To everybody else, just greetings. And again, thanks for joining me on this Saturday, at least Saturday my time, including now Tony, Tim, Rondell, Jason. Thanks. Greetings to you all. What I was going to do was to bring you up to speed about GTII, talk about a couple other things, and talk about my new role. I think I've referenced it already. Obviously, this is not legal advice. Obviously, it's also not financial advice. I don't want that to be misconstrued about anything I say today. So please like, subscribe, share, comment, because that's good if you do that for me, if you do that. So feel free to do that, although there's no obligation. Although today, for today's purposes, anybody who is currently listed as watching this owes me $500. I should have told you that before we started. But thank you to all you out there. Joe, I will send my address to you. So welcome. I appreciate that. And Stephen, and Christopher, thanks again for volunteering to pay me $500 for today's live stream. So I appreciate it and looking forward to it. Besides that, before I started, of course, I wanted to lay some groundwork. So I have a couple things to state. One, why couldn't the impatient sailor spell? Because he got stuck at sea. Get it? Number two, and this comes from any somebody out there, Big JR, not little JR, but Big JR. So thank you, Big JR. He sent it to me this morning. I told him I didn't say exactly I was going to use it, but I didn't discourage it. And if anybody sends me a joke, I will try to incorporate jokes from other people every week. If you send them to me, and I'll give you credit also. So this is some Big JR. I modified it a little bit. That's kind of a question I had, is which one you like better. So, and I may have gotten it wrong, but let me see if I got it right. So this is JR's version, and then I'll give you my version. I told my ex-girlfriend to meet me at the gym, but she didn't show up. That's when I knew we were not going to work it out. That's JR's version. I applaud JR. Fantastic. My version slightly different. Let's see which one you like better. His joke, my version. I told my oh, by the way, it wasn't his ex-girlfriend. It was not an ex-girlfriend. It was somebody else. So my ex-girlfriend was already an improvement on the joke, just to be honest. But I told my ex-girlfriend to meet me at the gym, but she didn't show. That's when I knew it was not going to work out. So I happen to think I like my line better, but it's very subjective. So whatever goes, goes. And last but not least, and this is certainly least, 2 goldfish are in this huge, shiny tank. One turns to the other and says in a very loud voice, "Do you know how to drive this thing?" Thank you for listening to those. So I wanted to talk to you about, I thought that was funny, by the way, that last one. Not my joke, unfortunately. Wanted to talk to you about the status of GTII, my status with GTII, what's going on, what I expect, and kind of a little bit about Alpine, a little bit about what I'm doing, my own investing stuff. Usually I found whenever I like boast about my investing, that's usually the high point, not the low point. So take it with a large degree of skepticism. But first one I wanted to do is kind of bring you up to date what's been going on. So what has been filed recently? It was filed. So now I'm talking about GTII. So we're clear. Recently, there was a motion that was filed to set a claims period. That motion is going to be heard May 27th or 28th. I think it's set on May 27th, but it's possible it could be heard on May 28th. And that basically will start the period of time in which people have the right to submit claims to the receiver. It'll be 90 days from the time at least my recollection is, there's no order in a place yet. So, but it'll be 90 days from when the order is entered, and then there'll be a process in which the claims are reviewed and et cetera. So that motion is pending, and I expect the court would probably grant that. I don't see why it won't, but that's my guess. And that motion is set to be heard on the 27th of May. On the 28th, there's a status conference set up for the court to find out, basically the status of things. That's commonplace that every so often the court will hold hearings just to kind of get a feel for what's going on. Additionally, there was a motion that I think, again, I don't know it yet. I'll probably know better next week, which I'll report on at that time. But there'll be a motion involving the status of shares that'll probably be filed very shortly, I think within the week, but I'll know that better this week. And both those two motions that I just mentioned, those are important for the target to complete the transaction that we've talked about. So there's in the background, AIversity is in talks with the receiver, and they're trying to consummate a deal. And I know these two motions, one that's been filed and the one that will be filed, are important to both, and to AIversity being able to go forward. So I look forward to the second motion being filed. Just to complete the cycle, there was another document that referenced, I think in one of the motions, it referenced that the receiver's report would be submitted on or before the date of the hearing of the motion. Since the motion is going to be heard on May 27th, and I expect the next receiver's report to be filed before that time, because that's what the counsel for the receiver says, and I would assume they didn't say that if they couldn't do it. So that's what I would expect, absent some change. And then we'll probably hear about the audit. I hope to find out more information about the status of the audit in the coming period of time. And I'll talk to you about that in a second. Just to understand, there's a difference in the roles of counsel for the receiver versus counsel for plaintiff. If you guys, I don't know if you guys remember, but there's a lawsuit that was filed in Nevada, and there was a couple hundred plaintiffs. That counsel, Alex Calloway, and his a partner of his, are basically running that. They got the receiver. They were able to show the court that there was stuff going on. That's how the receiver was appointed. So Alex's firm, represent about 200 plaintiffs. Then there's the receiver, and the receiver has a separate attorney, and the receiver's attorney is not the same attorney for the plaintiffs, and their interests are different. So even though their interests may be aligned, their interests are different. The receiver is trying to basically get the company back into shape, collect as much as they can, satisfy whatever criteria need to be satisfied, file whatever reports need to be done, complete the audit, etc. The plaintiff's attorney, and who got the receivership set up, is trying to kind of tee it up for the receiver to move the ball forward. And that's by how the receivership was set up. So kind of different sets of counsel and different interests. And then on the opposite side, there's a bunch of attorneys either representing Reichman or Mrs. Reichman, Kathy Griffin, and some others. And they're in various locations. So there's a bunch of other attorneys involved. They have competing interests also with us. And I'll address that in a second. It'll make more sense when I address that. I think I put out a tweet. I don't think I really specifically have addressed it in detail, just to kind of explain the difference, but I will. So I talked about a couple of filings. Now there's a third filing that had happened in the past, and I probably mentioned it, but I thought it was kind of like worth mentioning because the order just was signed and it just was posted. So back in December, David Reichman asked GTII to indemnify him and advance his legal fees because I guess the argument, again, I didn't see those papers, but I think the argument was that the legal fees that he was incurring were in furtherance of his duties as an officer and director, and there's a provision in the I think it's the bylaws, the bylaws of GTII that says that if certain circumstances arise, and maybe there can be protection of the officer director, and the fees could be paid basically or reimbursed. So they filed this. They incurred. Just think about this, because the reason why I bring this up, because I just want to demonstrate the extent of, in my opinion, and all this is my opinion, the extent of the depravity in terms of even like the legal process here. So I guess in the original application, which is December 19th of 2024, they sought the return of legal fees in the amount of $63,000. And I don't know specific, and that was for services rendered for the period of time. Think about this. For services rendered during the period of time of October 19th, 2024 through October 30th, 2024. So that's for a period of 11 days, which means that's 5,000, 6,000 a month, 6,000 a day, 5,000 a day. That turned out to be, I think the papers show, $1,100 an hour, or in excess of $1,100 an hour for the work. And also he sought an order saying that for all the future stuff, you got to advance basically the fees and not out of my pocket. And then, the reason why somebody does that obviously is because it's going to either cost a shitload of money to defend themselves and pursue or defend against litigation. And people similarly situated, if they don't know this, I'm educating them. It's going to cost a shitload of money to defend yourself in a fraud case. Honestly, that's just the bottom line. But that being the case, if there's any kind of obligation for somebody to get coverage, then they're going to ask for it. If there was insurance, they would ask for it. But insurance can't indemnify intentional acts. And even in the bylaws that are cited in the order, it's the order that was entered by the court this week, it's referenced that the officer and director has to be operating in good faith. So I guess the question would be, and so the request was denied, and the court denied the request. So David Reichman has to bear his own legal fees and costs. We don't have to reimburse, although he could make a reapplication at some point in time. I think if he made a reapplication, the likelihood is it would be denied too, and I would certainly be one for opposing that also. But it seems like a requirement is good faith, and I don't think there's a good argument that the management operated with good faith, so this is denied. So this was also announced this week. So another interesting part, I really think the judge is not, confused as to what is going on here and knows. And that's why he issued set up the receivership in the first place. So on top of that, a motion was filed that's pending. I think it's set May 27th, and we're doing it by motion because that's the easiest way to do it, that Alex deemed, is the withdrawal of the law firm representing the plaintiffs, and I will go in pro se, which means that I will be representing myself. And I've discussed this with Alex a couple times in the past. It was my suggestion, not because I was dissatisfied in any way with the work product they were doing. It provided an additional layer away from me being able to speak to the receivership's counsel. So if I wanted to communicate something to the receivership's counsel, I'd have to communicate it to our counsel, and then our counsel would communicate it to them. Now, it may be the case that the receivership and I differ anyway, but it also might be the case that, the way a third party would present an idea that you might have more enthusiasm about, it might be received differently also. I don't know. That'd be reasonable, and I'm not attributing any fault to anybody about that, but that might be a reasonable conclusion. But I wanted more direct, immediate access to the receivership's counsel. And the problem is, when I was represented by counsel by Alex's firm, there's an ethical rule in law, and this is like one of those, everybody knows it, that if a party's represented, the other side can't have their counsel can't have direct contact with me. And that's even if I want to, whatever, you can have, it's not like we can't say hello, we can't have incidental contact. That's not the case, but they're not supposed to talk to me without my counsel being aware of it, consenting to it, me consenting to it, etc. So as a result, justifiably, receivership counsel is reluctant to communicate directly with me, because that shouldn't be done. And they know it, I know it, etc. Even though I am often trying to encourage it, but I understand their reluctance, whatever. So if I'm in pro se, though, if I'm representing myself, then there's no kind of a barrier between me being able to communicate with the receiver's counsel. And when I am able to communicate with the receiver's counsel, which I anticipate I will be able to, since I'm expecting to speak to the receiver's counsel this week, I think I'll have a better grasp of what's going on. Now, again, the interest of the receiver and our interest, and I'm saying our, because just so we're clear, I have no legal obligation to anybody in the community. So I'm just so we're clear on that. But the way I see myself, and might be a crazy thought, but I see myself as somewhat of a caretaker. So I try to represent the interests of the entire community. That's the idea. Obviously not getting paid, not requesting to get paid, whatever, but that's the position I have chosen to put myself in. So being able now to directly communicate with the receiver's counsel, even though the receiver's counsel may be on a different plane, may disagree, whatever, I think allows us to have a better understanding of what's going on in the grand scheme of things, and lets me, when appropriate and when I know, kind of discuss it. And I think that's going to be unusual, because it's rare, I believe. I think it's rare. It's rare where you have a dispute and a attorney who's a party, who has a channel, who could talk about it. I think that's an unusual setup. And I don't really think it's rare to have seen that. So I think we'll be able to kind of get firsthand or better information, maybe utilize it better, get better results, but certainly be able to keep better track of what's going on. Again, no disrespect to anybody, no, not calling anybody out, whatever. It just puts us in a different position, because now I am one-on-one. And I will appear whenever the hearing is on the 27th or 28th. I will appear on behalf of myself, but again, with my mind being in the interests of the community. Now, I think what will happen is, even though I will continue to report no difference, but I think you'll get the extra. If you're a plaintiff represented by Alex, I believe that he will be generating some type of letter. I think it'll probably be signed by both of us. That'll kind of say, because it was strategically advantage, because Richard thought it was to a strategic advantage, and we agreed, and we're all on good terms. He's going to be representing himself. You can contact Alex directly if you have questions. You obviously could listen to me too, and you'll get my input at all times. Ultimately, you make your own decision what you think is most credible. Other than being a shareholder who can't trade GTII, because I can't, because it's not tradable, I have no other pecuniary interest in GTII. I don't own an extraordinary amount of shares, so this will be okay. Anything could be life-changing money, even if you own 1,000 shares. But I don't own. What do I own? Because I think it's public record. So I think I own 20,500 shares. I think of GTII. So if it goes to 1,000 a share, yes, that would be really good. If it goes to $2 a share, that would be good too, but not quite as life-changing. And by the way, in my mind, just so you understand how I think also, in my mind, the valuation of GTII at this point in time is zero. That's how I equate it. I don't have any expectation, which I think makes me able to operate a little bit with less anxiety over it, because I'm only looking at upside. I do have communication with AIversity on a regular basis, and John, I speak to him regularly just to kind of find out what's going on. And I know that he and his company are still very interested in pursuing this and are actively doing that with the receiver. I'm not involved in those day-to-day talks, but I know it's going forward, and haven't heard anything to the contrary. I think just a lot of the legal things have to play out. At least some of them will have to play out. Depending on how they turn out, I know there's other alternatives that could be used to complete the transaction, and I expect all the parties to explore all those alternatives. But at this point in time, I know that AIversity is certainly interested in completing this deal because I have communication with them. So that's me. So I'm going to be involved, and to the extent I can talk about things, I will be much more, much more directly involved in having an understanding. I think to this point in time, since I have multiple people I speak with who I believe are all good sources, so I'm comfortable whenever I say something. If I say it, I believe it. Maybe it's not true, maybe it doesn't come out to be accurate, but I try not to say something if I don't believe it's accurate, even if I couch it in some cautionary language. Like I think I've mentioned that before. I might say something and kind of condition it upon something, but usually if I say it, I mean it. And the conditioning is just legal talk, legal mumbo jumbo. But anyway, I think in the new position we'll be able to get better and more accurate information in a faster way, and I look forward to it. I look forward to the hearings that are coming up on the 27th, 28th. I look forward to the motion involving the shares. I look forward to getting an update on the audit. I know the last time I heard anything about the audit was very close to completion. It was just awaiting some confirmations from, I think, third-party attorneys. I think that's where we were waiting, although I don't have any official word on that. I don't know if that's been completed, but I know the thought was that would be in short term, so I would expect it any time, and I look forward to the receiver's report. Now, jumping on, so anything else that I need to talk about? So that's going on. And I know the receiver is actively engaged in discussions and seeking out stuff, but I hope to know more again in the coming week and new information, not just kind of a rehash of the old information. Quick summary of Alpine. So Alpine, which was the prime broker as the GTII. Some people believe there's a concentrated short position. Also the scummiest group in the history of the world, in my humble opinion. Not very humble, but it's my opinion. And the record, it's just clear that for 45 years they engage all kinds of misconduct. The real question is why the SEC and FINRA have not acted to this point in time. Series of events, including the fact that the SEC and FINRA said these guys are a risk to the public, but they're still engaged in business involving some investment banking deal with some company called Vocodia that has a market cap of like $4.93. Just kidding, but it wasn't a big market cap. Really small. Didn't make sense, and the investment banking angle didn't make sense. It was odd, and this was after I think the Supreme Court had denied Alpine's request to stop the expedited expulsion hearing. Yeah, so Alpine's involved in a bunch of Supreme Court stuff. There was an expedited expulsion hearing that went up to the Supreme Court. They won some hearing in the Court of Appeals. They're spending, jillions of dollars on legal fees. but they went up to the Supreme Court. Supreme Court denied the stay. So theoretically, there's an expedited expulsion proceeding that's ongoing. There's a petition by um, Alpine to the Supreme Court to hear their case, saying that FINRA is unconstitutional. At the same time, there's another expulsion proceeding separate than the expedited expulsion proceeding. So 2 levels of expulsion just before FINRA. There's also one before the NTCC that's on appeal also. But the one involved in the regular expulsion, the appellate division of FINRA approved it. It's now going to the SEC. They have about 60 more days to, I guess they said it was 90 days to start the appeal. It's indicated they're going to appeal, but I haven't seen the appellate document. And it's very possible, depending on what the Supreme Court does, that they, again, go back to the Supreme Court, because if they lose the expulsion proceeding, they're out. And there's a question under one of the cases that was decided last term, whether they should be entitled to a jury trial and not before the SEC. And I think they're going to raise that. I think that would be a better constitutional question, because that would involve actually where they were going to be kicked out. The expedited expulsion, they haven't been kicked out yet, so I think it's premature. The actual expulsion, because the SEC won't give them a jury trial, I think they could go right to the Supreme Court now, and they would have exhausted their remedies to the extent they need to do. The reason why you can't go directly to the Supreme Court, by the way, is the Supreme Court has very few matters when it has original jurisdiction, which means that if you have a claim, you can go right to the Supreme Court. Usually it has to be some appeal. So it has to go through the trial court and then an appellate court, maybe a higher appellate court, before the Supreme Court will even look at it. And if you don't do that, they can easily just reject even if it was a valid constitutional issue, they could still reject it because you haven't exhausted all your possible remedies. So it'll be interesting to see here about Alpine and why they're still in business. I have no idea. I always throw out the part about they also had a convicted sex offender that they try to promote as their point person with regulators. That's seemingly ridiculous. I saw a question about, I thought I saw about blue sheets. I'm going to answer the question. So I'm going to quickly switch to blue sheets, and that seemed like an MMTLP question. I saw there was, at least in some litigation involving MMAT in bankruptcy, which relates to MMTLP, I saw some kind of a protective order. And Drew did a great job, very articulately stating what that is. I guess my only limitation would be, so a protective order is an order that the parties would enter it into that often the court has to sign off on, that says all the stuff is either confidential or protected. It might be like, trade secrets of a business or something. But as opposed to making it public and public in the court file, we're going to keep it kind of separate and out of the public view. That's kind of what it is. It doesn't necessarily define what documents you are going to produce. It defines how the documents are going to be treated. It does suggest, and this could be done for strategic reasons or it could be done in good faith, but if you were going to, even if you were not going to turn over documents, you would operate in good faith by preparing to do that. If you were going to produce documents, then you would have to do that. So, but one or the other could be true. But the fact that you have a protective order doesn't necessarily mean that you're going to be producing a vast number of documents, but it could mean that. Now, on top of that, to kind of take it one step farther, if you have a protective order and the documents can only be used in the case, that doesn't mean, so this is the flip side of that argument, and some of the concern is if you get documents and it's in a private fashion, how does everybody else benefit from it? Well, if there's another action and you subpoena either the person or the documents, you can get an order to have those documents used in that new proceeding. It might be under the same guidelines. It'd be confidential in the new proceeding, but it might be like a whole series of proceedings where the documents are determinative. And at some point in time, let's just say it's TD Ameritrade. I'm just making up something. So let's say there's a case against TD Ameritrade, and somebody goes after them, and they're able to get some documents, or it's thought that they're going to get some documents, and there's some resolution. And then the next person does the same thing. At some point in time, it becomes very problematic for TD Ameritrade not to resolve the problem in toto. Not to say that they will, but at some point in time, as opposed to dealing with it case by case, you might want to do it in a different fashion, because it would be more cost efficient, number one. Because if you have to litigate every case by case, it gets very expensive. So there might be use for stuff that's even covered by a protective order that's not available in a case, that you could get through a subpoena in a new case. It might be covered by the same thing, but it might give you access. So interesting that there's a protective order entered into. It'd be more interesting to see what the documents will be and what they pertain to. But I appreciated Drew's kind of analysis. And, it's all good, these good steps, and we'll see what the production is. So that was that. Alpine I talked about, where they are. Oh, and last but not least, and again, this is clearly not financial advice. And I never do this, but I like to kind of, and I told you, usually when I do this, this means we're at the top of all this stuff. And, it's there she blows. Don't follow this. I just use this for entertainment purposes. But I've been in my 3 largest positions over the past few months have been IBIT, which is a ETF and a Bitcoin ETF. A leveraged position in Bitcoin, so that it was about 2-to-1 IBIT, and a company called Grab, which is basically a delivering financial service in Southeast Asia, in Malaysia. I forgot which country, but it has a following in that country, and that's what I'm playing with right now. IBIT and the leveraged Bitcoin ETF, because I thought because of the election that Bitcoin would be strong. And so far, it has turned out to be strong. It hasn't run. It hasn't gone crazy, but it's been very good relative to the market to this point in time. What happens in the future, who knows, by the way. Again, I warn you, who knows? If I'm talking about it, sometimes it may be toppy, kind of like that. But there also seems to be a lot of demand now for Bitcoin by all kinds of institutions. Does not seem to be retail demand, and that's based upon what they analyze is, I guess, in prior Bitcoin runs or crypto runs, they would look at the apps that would most likely be involved in selling crypto, like Coinbase, Robinhood, etc. And those apps would be in like the top 10 or higher when there was crypto runs. And apparently, if you look now, they're not very high. Now, could that be in part because there's less searches, because there may be ChatGPT and that stuff? Probably. But there probably is less retail interest, and it may very well be, institutional interest or sovereign wealth funds, whatever. And if that continues, that will support the price. We'll see. I'm looking forward to it, and I'm hoping it continues to move well. We shall see. I'm sure if there's a deal between the United States and China, that the entire, I don't know anything, but I would expect that the market will move sharply if there's some kind of hints at a transaction. I know there's a meeting today in Switzerland. I know I saw competing stories about it, that the parties were meeting through dinner time, so they were going to meet, something on the order of 10 hours. I don't know if that means anything. I don't know. You never know in negotiations. Long time means long time, but it doesn't necessarily mean that you're making progress. Maybe it's like groundwork for making progress, but it's good. It's good if it continues. If it continues, it's good if the information is accurate that it's continuing for that period of time. If in fact there's any release over the weekend or suggestion that there's progress being made, I would think the market would react positively about that, and we shall see. So again, I myself, even though I'm I've been I've owned all kinds of things. Currently, I'm big into the Bitcoin and Grab. And Grab I learned about through. I'm going to give props to somebody here. His name is Amit 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 Investing. He's like 27 years old, super smart, super entertaining. He's got his own YouTube channel. He's not paying me for this, not yet at least. But anyway, he's super bright, and he's a big fan of Palantir, Robinhood, and Grab. That's his three. And he got into Palantir, which is a AI related stock, not really AI, but we'll say that more of a data retrieval AI P stock. He got in, below 10. It's now like 120. So he did very well, had good foresight. Robinhood has had good success also with that stock. And Grab, he sees he liked the CEO very much, and he liked their exclusive their exposure in Southeast Asia. He liked the CEO who kind of stepped away from his father. But anyway, I recommend him because I thought he was really good, really detailed, really smart, and a young guy, entertaining. So I think if you want to get a view of somebody, that's good. For Tesla, if you're interested in Tesla, then Farzad's channel I think is really good. Farzad Misbahi, I think he's really good. Another guy I followed who's a little drier and kind of conservative, but also super technical and super interesting, I think, is Kartek at Money Investing. I think that's one word. I think he's really good too. Those are the three that I kind of watch. I watch Amit the most, I think, of the three. I watch them in the order probably I just mentioned. But anyway, I found there was good content. You could learn stuff, and they provided, quick information. It was entertaining. All that stuff is good. So, not that I'm suggesting that you go out and buy iBit or one of those leveraged iBits or Grab. I just wanted to put it out there so I could be on the line, on the hook for what happens to them. So the pressure is on. I think just so we have set the record right now. I think Bitcoin's about 103. That leveraged position is about $50 a share. And Grab, I think, closed at 493 on Friday. So this is May 10th, 2025 at 12:17 p.m. So now I'm on the hook. Whatever. It might be like 2 weeks from now, Bitcoin's at $14, that the leveraged Bitcoin's at minus $14, and that Grab now is delisted. That's possible. Hopefully not, but you never know. Anyway, so just to kind of go through what we talked about, or what I talked about, what I babbled on about, was talked about what motions were pending, the status conference coming up on the 28th, a couple of hearings on the 27th of this month, that the receiver's report is referenced as coming out before that the audit is nearly complete, that there was a court order entered where Reichman's attempt to get reimbursement for legal fees and advanced legal fees was denied. There is a motion for plaintiff's counsel, our guy, Alex, to withdraw, because that's the way we decided was the easiest way for me to get in the case. That I had previously requested it. It gives me direct access to plaintiff's counsel, to the receiver's counsel. And in the past, I couldn't have direct access because I was represented, and it's not proper for the receiver's counsel to have direct access to a party who's represented. So now we will have it different. I expect to speak to him this week. I'm intending to go to the hearing on the 27th, 28th. We talked about Alpine, that we're just waiting now. The next step would be the SEC, that appeal, and whether the Supreme Court takes the case or not. And by the way, if the Supreme Court doesn't take it now, the next time the Supreme Court could have this matter heard is the next term, which would be in October of 2025. I don't think it's going to happen before June. I don't think it's, paramount. The court's going to deem it paramount. So I think the first time that the Alpine matter might be heard, if it's ever heard, would be next fall. In the meantime, and I've said this a billion times, SEC and FINRA should go down and shut Alpine down if what the SEC and FINRA say that their scumbags have engaged in all this misconduct, with the also addition of trying to attempt to have a convicted sex offender be their point person in a way, which was denied also. So then I talked about Bitcoin. I talked about leverage Bitcoin and grab. And that is the whole plethora of events. I went on the hook for the prices at this time. And that's all I got to say. So to all you out there who stayed around, thank you very much. To those of you who didn't stay around, you're not going to hear this. So unfortunately, all is good. So I will keep you apprised of everything that goes on. MMTLP, I talked about the protective order and how that can be used in other cases. However, it doesn't necessarily suggest the extent of the production, but it's a good step, and that's a positive thing. And I appreciate Drew for having his analysis and really having a really good analysis. So anyway, that's all I got to say. Be well. Have a great Sunday. Have a great Saturday. Have a great Sunday too. If anything pops over the weekend, I will let you know. Be well, take care, and have a great day. And thanks.